felony DUI is very similar to a misdemeanor DUI in that the same basic elements are required for them to find you guilty of that charge. First being that you were driving a motor vehicle, and two, that while you were driving that motor vehicle, you were either under the influence of alcohol or you were driving with a blood alcohol level of 0.08 or higher. Misdemeanor DUI can elevate to a felony DUI in one of three different scenarios. First scenario is that you have at least 4 or more prior DUI or reckless convictions within a 10-year period. Therefore, every DUI after that, starting with number 4, becomes a felony DUI. Second situation or scenario where you can have a felony DUI is if you have a previous conviction of a felony DUI. So, for example, let's say you have a previous DUI where there is an injury and it was a felony conviction on your record. Even though you only have one prior DUI, every subsequent DUI after that would automatically be a felony DUI. The third and final scenario where your case can elevate to a felony DUI is if you have a prior vehicular manslaughter felony charge under Penal Code 192. So if any of those three scenarios are met in your specific case, your misdemeanor DUI can elevate to a felony CUI. If you are found guilty of or convicted of a felony DUI charge, you could be sentenced to prison for upwards of 16 months, 2 or 3 years. You would have to serve 50% of that time in custody. Now, in addition to that, you usually will have an 18-month DUI program, as well as fines and fees of upwards of $10,000. Now, there are many defenses to a felony DUI similar to that of a misdemeanor DUI. For example, a violation of your rights. If police pulled you over for no reason, you weren't speeding, they had no lawful reason to stop you, that's a violation of your rights, and that is not a lawful arrest or stop. Other situations could be that the police made some kind of mistake as part of their investigation. Maybe they waited too long to withdraw the blood from your body in order to test your alcohol intake, or maybe there is an issue with how the blood was withdrawn. There are many, many different scenarios and defenses that exist, and that is why it's critical to have a very experienced DUI attorney represent you in your case. Another common defense as well is that the prosecution has to prove your previous DUI charges. For example, if one is out of state and the elements of that crime that are a DUI in, let's say, Utah don't add up to the same elements in California, then that could not be considered a prior DUI. A felony DUI is much more serious than a standard misdemeanor DUI. Even if it's simply you were driving, you were speeding, and you were pulled over and received a DUI charge. But because you have 3 to 4 previous charges, this one becomes a felony. It's not a slap on the wrist. You could and will go to state prison if you are convicted of a felony DUI. Call the Inland Empire Criminal Defense today. I can help you.